A proposal arrives in your inbox. The company appears established, the executives sound convincing, and the documents use the right terminology. On first review, the opportunity looks credible, but 3 details do not align. Those details may separate a viable transaction from an expensive mistake. This is a fictionalized composite case. Names, locations, and identifying details have been changed, but the warning signs reflect issues that arise in cross-border business. A client was considering a substantial infrastructure transaction. The counterparty claimed access to private capital and relationships with major financial institutions. The project had a credible purpose, but the client was being pressed to sign quickly and disclose sensitive information. The first inconsistency concerned corporate history. The presentation described decades of international activity, yet the legal entity proposed for the transaction had been incorporated less than 2 years earlier. A new company is not automatically a problem. The problem was the lack of evidence connecting it to the track record being promoted. The second inconsistency concerned authority. Several individuals were described as directors, advisors, or authorized representatives, but public records did not support every claimed position. Who controlled the company? Who could legally bind it? And who would ultimately receive the funds? The third issue involved the transaction mechanics. The documents used sophisticated banking language, but the sequence placed most of the risk on the client. Sensitive information and preliminary costs were requested before meaningful independent confirmation was available. Technical terminology is not proof that a bank can or will perform. At AAL, we did not describe the transaction as fraudulent. The evidence did not justify that conclusion. Instead, we separated verified facts from reasonable inferences, unresolved inconsistencies, and unsupported representations. We examined corporate records, ownership, signing authority, sanctions exposure, litigation, digital history, document consistency, and the proposed transaction flow. Our recommendation was simple: pause and request focused, independently verifiable evidence. Some answers changed, other questions were avoided. The pressure to proceed increased. The client decided not to continue. That decision protected more than money. It protected confidential information, banking relationships, management time, reputation, and legal position. The lesson is straightforward. A professional website is not proof of capacity. A senior title is not proof of authority. Complex financial language is not proof of performance. Before committing capital, information, or reputation, ask one question: what do we actually know, and what have we merely been told? AAL provides commercial intelligence, enhanced due diligence, and strategic risk analysis across borders. Good intelligence does not tell you what you want to hear. It tells you what the evidence can support. Visit theaalgroup.com.